Good morning. Can I have some more energy and life in here? We are. Good morning, everybody. I'm free. God bless. I'm so happy. Okay, so I'm going to share some elements from my personal story. I'm going to touch on what I consider to be some important policy points, and then I'll cover a few miscellaneous topics. As has been said, I served 16 years in prison. I was arrested at the age of 16. I turned 17 by the time I lost a trial. I was wrongfully convicted of murder and rape here in New York, which my wrongful conviction was caused by a coerced false confession, prosecutorial misconduct, fraud by the medical examiner, and an inept public defender. The conviction happened despite a pretrial DNA exclusion. After 7 failed appeals and being turned down for parole, I was exonerated through further DNA testing, which not only reaffirmed my innocence, but it also identified the actual perpetrator, whose DNA was only in the database because left free while I was doing time for his crime. He struck again, killing a school teacher and mother of 2 just 3.5 years later. I was released with nothing. As a result of that, I was never able, it took me about 2 years to achieve any kind of stability in terms of housing. I bounced from one place to another place to another. At one point, very nearly ending up into a homeless shelter before Mercy College, which had already given me a scholarship to finish the bachelor's degree. They intervened and allowed me to live for a while in their dorms. Whenever I had to go to the city in order to meet with mental health professionals or my attorneys, I could barely afford the train ticket and the subway. As a result of being released with nothing and never being able to achieve gainful employment because I didn't have the same job history as other applicants that for jobs had, so that was why I was always passed over, and hence I was always in a destitute position. It goes without saying that barely being able to afford the transportation, naturally eating out while I was in the city was out of the question. So I'm not ashamed to tell you that in the state that I was, I had to put cereal in a bowl and put it in my backpack and travel with that. I was not above putting cans of tuna fish and spoon and a can opener because I couldn't afford to buy anything out. My family had become strangers to me. There were only a handful of them that intermittently visited me here and there, with often gaps of 2, 3, 4 years in between, and most of them did not visit me at all, and so it was always an awkward experience whenever I would encounter them. I knew who they were intellectually from memories from when I was younger, but having spent significant time away from them, they were different, they were changed, and I was changed. I lost connection with all of my former friends. Although I was released at age 33, that was not really my age emotionally and inner. That was really my physical age. So to me, I still wanted to throw a ball around. I still wanted to go to an amusement park. I still wanted to jump off the diving board. All these type of social activities that other people my age were not into. They were past that stage of life in general. And so putting together a new social circle proved to be really impossible. And so loneliness was an extreme obstacle for me. In terms of being able to find a spouse, the stigma of having spent 16 years in prison was an obstacle. Was it safe to be alone someplace with me? For even though I should be the same as any of you who've never been arrested and spent time in prison, the fact of the matter is I did spend time in prison. And so that stigma, being able to shake that, proved to be difficult in the eyes of some people. In terms of policy, I do applaud the changes that are proposed today. I want to make it clear that from my position, we still need to do more for exonerees. From the point of release and to the time of compensation, there's an average length of time between 3 to 7 years. What happens to the exoneree between when they're released and they get compensation, assuming for a moment that they do, because that issue's already been covered. I believe that it's critical that exonerees be given temporary housing. immediate free mental health services. It's typical that people who have spent time in prison wrongfully, that they have PTSD, panic attacks, anxiety attacks, being afraid of simply seeing a police officer, the feeling of having been suspended in time, the feeling of moving at a much slower speed than the rest of the world. A social worker is a critical aspect in terms of trying to rebuild ties with friends and family where that's even an option, because often, for a myriad of reasons, it's not. Being able to identify what goals has and then pointing out those steps, delineating a path to achieving that. They need temporary housing, emergency funding for things such as clothing and food items and public transportation. We need to have training to get reoriented to new and improved technology. Job placement and job training are also critical. And then lastly, I'll wrap up on that point as far as policy-wise. There are definitely medical and dental needs, from an initial physical to ongoing treatment for any afflictions that have either been caused by or exacerbated by being in prison wrongfully, as well as dental care. A few quick miscellaneous things that I want to make. I took a portion of the funds that I received and I started a foundation, the Jeff Deskovic Foundation for Justice, and our fourth component has to do with reintegration. So in some of our, we've worked with a couple of exonerees. We played a small role in exonerating William Lopez, who served 23 and a half years in prison. Eric Glisson, who served 17 years and 9 months. We had nothing to do with his exoneration, but we did work with him reintegrative-wise. And there's other people on other different levels who I'll just keep anonymous that we've had some dealings to one extent or another in the reintegrative side. And so some of those things that I've learned from that perspective that are important, regular contact. A lot of the guys tell me that people that just come up to them randomly and they never hear from them again, that's not as helpful as people who are become regular parts of their life. If it's only a phone call a week, just regularly checking in and seeing how things are doing, where the phrase, "how are you doing," is not simply a cliche, but has some depth and meaning behind it. There's definitely a balance. On one hand, you have to respect the newfound freedom and choices of the person who's been released, and you have to allow them to make their own choices and make their mistakes and their successes. And at the same time, you don't want them to make mistakes. You have to figure out, but you can't be overbearing. So you have to find that balance. So finding that balance is important. Assistance in terms of navigating bureaucracies. Case in point, when I lost one of my appeals based on being 4 days late. So I was always afraid if there was a bureaucracy that I had to navigate, that there was going to be one kind of a glitch or another that was going to trip me up. And so I think having somebody there whenever there's a process to be navigated is important. Lastly, a lot's been made in the innocence movement about the idea of pairing exonerees one to another, almost like a support person. I guess drawing on the analogy of, say, if you have a couple of recovering alcoholics or former drug addicts who turn their lives around. So there's a similar theory trying to pair people up. My experience, both in terms of personal as well as I've had conversations with about 70 exonerees in the 7 years I've been free. That doesn't work in terms of when you try to set it up by remote control. If it's just a phone call, if it's mechanical, if it's cold, that doesn't work. I think that reasonable distance proximity-wise, when it's in person, then that's a lot different. That's a lot different. So with that, I'll close.
So I want to thank Jeff and all the panel, and we're going to open it up to those of you on the floor. I'm wondering if we know anything about the ages of people at the time that they were wrongfully convicted, and anything else about. Oh, Karen. Karen's the one. Can you use the mic?
Information that we have on our website too. I do. Okay, hello. The average age is, at least of the DNA exonerees, which there are currently 312 post-conviction DNA exonerees, the average age is 27. So, and I have worked with, I don't know how
When
many.
they were convicted or when they're exonerated?
At wrongful conviction.
Uh-huh, thank you.
And then the vast majority of them are African American, something like 60-something%, I believe, of the DNA exonerees. The average number of years is now 13.6 years. I have many clients who have served more than 2 decades in prison, and by stating that, I don't mean to minimize at all people who have served less time than that, and certainly each exoneree has a different experience in prison. But we have many clients who've served more than that number of years. And I'm trying to look and see if anything else other than the age and the race.
What I just wanted to add is I think that the younger that a person is when they were wrongfully imprisoned, I think, I mean, that's a smaller subset. I think that that presents some unique challenges, although there's some overlap because the obvious normal development in a natural span of life wouldn't have taken place out in a free society.
Right, thank you.
I was just going to add that one thing that our research on exonerees was kind of an interesting test of is that, Anne probably knows more about this than any of us, but there's a hypothesis called prisonization, and it's the idea that people who spend lots of time in prison are socialized in a way that's counterproductive. So if you take the subset of our population of young people who did nothing prior to being wrongfully convicted and look at what they do following release, that's kind of the purest test of prisonization that you can imagine. It's like we ran a social experiment. The only difference is we ran it solely with subjects who are powerless and almost always black and poor.
One thing I'd just like to add is, like, for me, I mean, because I'm asked a variation of this question a lot, and, you know, my personal experience, the key is, while understanding the prison mores and rules of survival to survive, not internalizing those values.
Thank you. So are there questions or comments from the floor over here?
We should all be 1,000% behind the efforts here.
Would you identify yourself, please?
My name is Anthony Pappas. I'd like to comment on the obstacles that Attorney General Schneiderman pointed out. To my mind, these are all examples of like legal sophistry. You know, if I falsely confess to something, I may be deranged, I may be ignorant, I may not understand the English language. I do not contribute to the crime. It would be very easy for Chief Justice Jonathan Lippman and his cohorts on the Court of Appeals to just come out with a landmark case saying that you don't contribute to the crime by an innocent confession or a coerced confession or a deranged confession. Why don't they just do that? Same with expungements. It should be totally logical that you should have something expunged, and the court system should just easily rule on that, but they're sort of like brain dead and they don't do that. So one of the additional things we have to work on is the issue of like brain dead judges. In my case, I've had 3 brain dead judges who keep writing, I committed a violent Class B felony. So I should be up in Attica State Prison. They know it didn't happen, but they keep writing that. They also keep writing, I made thinly veiled threats in the idiom used by the perpetrator of the Fort Hood massacre. I can't stand before you and make threats like the perpetrator of the Fort Hood massacre. So if we don't deal with the effort of brain-dead judges that destroy lives and families and take children away from their parents, we are going to still have a lot of injustice and unfairness in the system. Thank you.
Thank you.
Can I just one comment I just want to make is that um, I think that we do need to have better appellate review and catching errors. It's a shame that a common element in wrongful conviction cases is that by the time the person is exonerated, their appeals were long since exhausted, and there were numerous red flags to indicate that along the way, but there wasn't judicial intervention. So I'm using my own terms, by the way. I'm not, but I think that the problem of the judiciary and as far as it leading to wrongful convictions continuing, that's also an element that I think is too often left out of discussions about wrongful convictions.
So I don't want to denigrate the judiciary, but there are instances where judges could be more effective in dealing with some of these issues. But I think you have to remember that judges are supposed to follow the law, and that's why Attorney General Schneiderman is seeking to change the law so that there's a basis for individuals seeking redress under the law as opposed to it being currently limited. You have to also look at the legislative history. Now, I actually haven't looked at it, but I suspect that what they did when they talked about people contributing is they specified when they were dealing with the legislation that if people confessed or if they pled guilty, that they shouldn't be entitled to seek compensation. So I think it's not simply that the judges can just come in and change what has been a longstanding practice.
But just to add, though, what they could do is we do have a constitution in New York, and they can declare it unconstitutional under the New York law. When we want, as a society, when we want to prosecute people and put people away, there never seems to be a problem in terms of stretching the envelope, coming up with unusual interpretations in order to achieve what's perceived to be justice from occurring. Why is it that same ends of justice approach couldn't be applied when we're talking about wrongful convictions, not even just on the compensation side, but even in terms of correcting and halting wrongful convictions, and in terms of the normal causes of wrongful convictions. I mean, there's laws to, it's illegal to coerce confessions. You're not supposed to allow a suggestive identification. There's existing law that judges can and should, but too often fail to intervene in.
I don't want to dispute that. That's certainly true. A large percentage of cases, I mean, there have been coerced confessions. In fact, there's now a case up, two cases before the Court of Appeals where they're actually looking at the techniques used by the police. Not necessarily that they were people were under duress, but I forgot the term.
Reed technique?
The Reed technique was utilized to get individuals to confess who, in fact, have claimed that they were not. And I think the evidence, aside from those confessions, really seems to indicate that they were not guilty of the crimes.
I'd like to, for a moment, I am about to.
Oh, thank you.
I'm Richard Blasberg, and I'm the Assistant Director of the Jeffrey Deskovic Foundation for Justice. I'm also a former probation officer and criminal investigator. One issue that I would like to raise here is that, yes, it's tragically ironic that persons who were innocent and who served sentences for crimes they didn't commit come out to discover there are no reentry supports. I know that only too well in Jeffrey's case. Jeffrey used to write a column for me in the Westchester Guardian. And that was basically the substance of your support.
It was.
He was turned away by every conceivable, including the church at which he had been an altar boy. No housing for him. That's tragic, but I want to make a different point. Of course, because Attorney General Schneiderman used this, and very welcomely so, used this as a launch pad for very needed changes in how we deal with persons who've been wrongfully incarcerated. So we're kind of going in that direction. But I truly believe that all of us in this room have got to take into account what it is that persons who have been exonerated, who were innocent, bring out of the prison environment, as well as those who are paroled after they've served their time. And I want to give a very, what I think is such a basic and fundamental illustration of how poorly both the Division of Parole and the Department of Correction, who are now working much more closely together. As Jeffrey knows, we've been successful in getting persons who we believe to be innocent help their parole process. That's the best way to explain it. Here's a very fundamental issue. There's about 60 correctional institutions in the state of New York. Some of them have conjugal visit provisions. Some of them do not. You have, I'm going to give a case in point of obviously not mentioning a name, but one of our own cases. You have an inmate who's been married for 9 years. For 6 of those years, he was in Greenhaven, and they had conjugal visits. Then, through no fault of his own, and perhaps because it was deemed a more desirable location, he was sent for the next 3 years to Otisville. No conjugals. What do you suppose that did to the relationship between that husband and wife? Every single prison in the state of New York should have trailers and provision for those married people to maintain some semblance of intimacy, in my view. And you can't get more fundamental than that. That particular couple, by the way, are breaking up, despite the fact that he just recently came out. Small example.
Thank you very much. Thank you.
Good morning. My name is Jose Castro. I'm a junior here at the college. Hi, Jeff. My question is actually for you.
We know each other outside of here, actually, by an unusual human interest story. But please continue. I'm happy to see you here.
Yeah, I'm glad to see you. So you did mention, I believe, that you were coerced for a confession, right?
Yes.
So then what's so special about your case that it kind of exempts you from this AB rule that I heard about earlier today?
Well, because it's a good question, by the way. I haven't gotten that one before. Is because I didn't have to litigate my 8B claim. I filed it, and the Attorney General, who was not Schneiderman, his predecessor, settled the case prior to my having to litigate it. Had that not happened, I would have had, that would have been the government's defense, and I would have countered and said, well, I was coerced, and, it's a coin, it would have been a coin toss. So that's what happened.
Anybody, we're going to get some people who haven't spoken and then come back to you, okay? The woman in the back, second to last row. Oh, I'm sorry. Right after.
It was a misidentification. Imagine that.
I'm exonerated.
Happens all the time.
Yeah, imagine that, right?
A two-part question. One, in terms of coercion, would plea bargaining, which is very common in our system, and sometimes your attorney may just advise you that given the data, it's the route to take. That's the first part of the question. And the second part of the question, which is in the other Western nations, having, for instance, a civil system, or in Europe, how different are exonerated people treated? And I realize there are many countries there, but is there any trend? Is there any different attitude?
Well, let me take a stab at part of that. I can't answer the whole thing. I'm hoping the panelists can clean up after me. But if your first part of your question is whether or not innocent people have pled guilty to crimes in a type of pragmatic decision to try to minimize the loss, then the answer is absolutely yes. I used to know off the top of my head the number of people that were exonerated by DNA in those instances. Karen, do you have the exact figure? All right, so she'll look at that. But the general answer, until she comes with a figure, is yes. I can't answer about the whole other countries, except that I'll say that in Britain they have a procedure for challenging a conviction. I forgot the technical name of it, but you can it's an apparatus outside of the normal appeals process, and the standard that they use in determining whether a person is been wrongfully convicted or not is whether or not the conviction is considered to be safe or not. So it's a little bit less than having to, make a strong actual innocence showing. You can demonstrate that there's a reason, sufficient reason to question it. So beyond that, I'm hoping the other panelists can add something.
Seymour and then Evan.
I don't have any information about Europe, but with respect to your first question, I think the system in New York and across the country really is coercive. Because of mandatory minimums, people face such substantial amounts of time if they will risk going to trial that in many instances, they're in effect forced to take pleas to avoid that risk. And I think that's what occurs in many instances. People are so concerned about the large number of years that they'd be forced to do if convicted, that they will take a plea to minimize the risk, and so they can be released at an earlier time.
To build off of I agree with you, and to build off your answer, another phenomenon that's starting to emerge is that after a wrongful conviction is reversed, if the district attorney decides to retry the case, then a growing trend it's happening is people have taken pragmatic plea bargaining, even in some instances where DNA has been the basis of a reversal, but the district attorney is so determined not to concede error that they're going to retry, and the defendant is afraid to be reconvicted. And so we've seen plea bargains in those situations as well. Just normally it'll be like the time served and your freedom is secured and you simply would be on parole. But what the government gets out of it is they don't have to say they made a mistake, a conviction stands, there's no compensation. And what I found to be particularly appalling, and in the West Memphis 3 case, this is particularly telling because the district attorney went on record making public statements after the fact. He actually said after he secured the plea bargain, right? And this was where there was DNA and other evidence showing that the men were innocent. He said, well, if I had went back to the judge, it was likely the judge was going to overturn the conviction, and had I taken it back to trial, they would have been acquitted, and then the state would have had to pay millions of dollars. And so that's why I insisted on, and that's why I offered the plea bargain agreement in which everybody pled guilty, though verbally protesting their innocence.
Evan, do you have some stuff to add?
Sure, just briefly, your question directly was whether the plea bargain can act as a barrier to recovery, right? The answer is it can. Section 8B doesn't specify how you can contribute to your conviction such that it acts as a barrier, but some courts have interpreted the plea bargain as a barrier, right? It's one of these.
And to build off of your point, to add, I don't want to dominate the telephone, I add some other information. In terms of we haven't really talked about compensation under federal law, 1983, the Civil Rights Act. There was a recent decision, I forgot the title of the action, but it stated that if someone pleads guilty after their conviction's been reversed, you can still go into court and seek compensation that way. So it was a really, really progressive, I think, Mr. Blasper, can you have the answer of the title? All right, so then I won't. But you can still seek compensation in that case if the facts in your case fit the standard for prosecuting that lawsuit.
And on the question of where the United States stands in relative terms, the answer is basically worse than average. There's a lot of variation. You wouldn't be surprised on that. And some more progressive countries like Scandinavian nations come to mind that do better. But what's interesting to add to that answer is what would an effective compensation statute look like? So we kind of scored New York as not at the bottom, but far from the top. It's not at the bottom because there are some states that don't allow it at all, right? So it gets some points for at least allowing some people to get recoveries, as Jeff was in the minority of people who did. But a better compensation would set a floor amount per year of wrongful conviction that actually was a dollar amount. I mean, some of the dollar amounts are scandalously low, right? I mean, there are state statutes that give somebody $5,000 or $10,000 or $20,000 a year per year of wrongful conviction, which isn't obviously even close to what they would have made had they been on the outside. So if you're talking a dollar amount in the hundreds of thousands of dollars per year, and another element which Jeff got it, which is important, requiring litigation adds a component to it that's going to act as a barrier for most people because many exonerees are not going to have access to the type of lawyer who can handle a claim like that. Ironically, there's lots of variation in the United States among the states. Texas just passed, and Texas is the worst, the worst transgressor in terms of overuse of the death penalty, but they actually have the best victim exoneree compensation statute. It's very little cognitive dissonance there.
I want to, is it okay if I speak? Okay, I'll let you go and then I'll respond. I'm sorry, Karen, I want to cut you off. Go ahead. I'll go next.
I just wanted to mention that when Attorney General Schneiderman was a senator in 2010, he proposed legislation that is very comprehensive and mimics much of the Texas compensation statute that was passed in 2009, the Tim Cole Act, which is the, I hate to use the word generous, but is up till now the most generous compensation statute. His proposal back then in 2010 was $75,000 a year for each year incarcerated, reentry services, immediate cash assistance, all of the things that the Innocence Project proposes in its model legislation, which is up on our website, and I think probably which appear in everybody's recommendations. So he actually has contemplated and even proposed much more comprehensive legislation than what he came out with today. Again, we thank him for what he's done. Every little bit helps, but it's not enough.
But one of the points that struck me in reading before this panel was just how costly it can be for someone to pursue their right of expungement and the amount of legal fees that they could incur in trying to do that.
It's an interesting finding in our study. So we actually, if you just looked at how people who were compensated fared versus people who weren't compensated, there actually wasn't a difference. It's only when you broke it up among people who got zero compensation, people who got a small amount of compensation, which we defined as less than $500,000, and people who got more than $500,000. The people who got more than $500,000 did substantially better. And I think your point, Ann, alludes to the reasons why